accused 1, Danny Jordaan, accused number 2, Trevor Neethling, accused number 3, Groni Hluyo. Your Worship, this matter was remanded on the last occasion for the state to give the outcome of the representations that were made by accused 2 and 4, Neethling and Grid Communication. The outcome has been made. The acting national director of acting director of public prosecutions has made his decision. He made it late last night, Your Worship. He had just joined our division just on the 1st of this month. He was so inundated with a lot of decisions to make. Hence, it took him until yesterday to make a final decision. The outcome is that the representations are not successful, and the decision has been conveyed to the defense. And further, Your Worship, we also received the review for representations from the attorney for accused 1 and 3, Mr. Nkwashu, late afternoon around 1 o'clock yesterday. But I believe the decision has been made already by the acting DPP. And at this juncture, Your Worship, there are certain High Court matters which are impacting this matter. There is an application for the review of the search and seizure that was conducted in respect of this matter. And the said application is being made by accused 1 and 3. And the matter is still outstanding in the High Court, so it's also impacting this matter. When I spoke to my colleague, Mr. Nkwashu, and after the information that was given to me, the matter has been set down for the 8th of October 2025. It's an interlocutory matter on the unopposed interlocutory role at the High Court. So it's also one of the reasons that today we are here, and then we will be seeking a further remand to deal with those issues. We also have further disclosure to give to the defense. The said disclosure, Your Worship, was occasioned by the fact that during the review application by accused 2 and 4, further information was given to the state on which they were relying on their representations, which the state had to go and verify. It involved emails, having to go to the firms that are dealing with backing up of the data, which was not an easy task to do, but eventually the state managed to get the relevant service providers, and we've got that information, and we will be disclosing it to the defense. And now I have spoken to Mr. Ndabele, the attorney for accused 2 and 4. I didn't get a clarity on what is his next step, but I believe he would want to peruse this information before he can decide on the next step, Your Worship. I think those are the issues. In the meantime, we have a date on which this matter would be remanded to Your Worship, which is the 21st of November, 2025, Your Worship. That's the conference.
Thank you, Mr. Nkwashu.
Thank you, Your Worship. Your Worship, I confirm that I act on behalf of the first and the third accused. There are issues which we confirm, which my learned friend has placed on record. One of which is that we have submitted a review of the decision of Mr. Nkwana to the DPP's office. And I understand there's a new acting DPP who has since been seized with the matter. I have received a response from him this morning at 4, in which he stated that he declines the review, and one of the reasons is that the investigations are ongoing in this matter, meaning that the investigations are not complete in the matter. It is in writing, we have it. I did not print a copy, but my learned friend's response states that the investigations are ongoing. Now, this is on the face of a 342 having been brought, argued, and dismissed, and another notice having been given on the previous appearance that by today the state should have its house in order. Now, amongst others, Your Worship, is that the state has now informed us that they have a 64 gig of information that they would like to disclose to us. And it would seem that they had this information before 4 a.m. this morning when they sent the letter to us. And the most sensible thing to do would have been to ask for our comment on such information before making a decision on the representations or the review thereof. However, they decided to make a decision on the representations whilst they have new information which they want to disclose to us. On the same letter, they say that the investigations are ongoing, meaning they're incomplete. And they also intend to amend the charge sheet. So, a notice in terms of 342 has been given to the state that by today they should have their house in order. It's clear that their house is not in order. If the letter here, under the hand of the acting DPP, says the investigations are ongoing, I'm going to amend the charge sheet. It's clear that, and I'm going to disclose to you further information, it's clear that this matter ought not to have been enrolled in the very first instance. And Your Worship, this issue was brought to the attention of the state right at the beginning of the enrollment. An application was brought that this matter should not be enrolled because it will inevitably be delayed by the review applications that are in the High Court. By the time they enrolled this matter, there was already a pending review of the search and seizure in the High Court. Now I want to deal with that specific review application. This is a review following a search and seizure at SAFA House, which was widely publicized. Now, an application for setting aside the search and seizure was brought in April 2024. The final replying affidavit by the applicants was filed in March this year. Now, just to show the blasé manner in which the state is conducting this review, is that on the 5th of September, last week, they sent us a letter asking for proof of service of the replying affidavit, which was served on them in March. And the reason why they're asking for that proof of service, which we gave them, and I have a copy for Your Worship if Your Worship needs, is because we engaged the Office of the Deputy Judge President to intervene because they are not complying with the uniform rules of court. They have not filed their heads. We have filed our heads. We're looking for a date for hearing. We cannot get a date for hearing because they have not filed their heads. They've now responded to say that in August last month, they responded to say that their counsel was engaged in a trial will only be available at the end of August. They were given an indulgence. Yesterday, they wrote to the DJP to say that they have not paid, the state attorney has not paid their counsel. Therefore, he's refusing to assist with the filing of the heads, the drafting of the heads. Now, this, Your Worship, is a delay which was already highlighted to the state when they enrolled the matter, that they should not have enrolled it in the very first instance. Now, what are we left with? We're left with a matter that is not ripe for trial, clearly, because the investigations are ongoing. we have made representations which have been declined, then been given this further disclosure. What is then to happen? Because we're not going to get a date for hearing this year if the state, in the very first application for review, have not filed their heads of argument. Following the heads, there must be a joint practice note that must be filed by both parties, and we must seek a date for hearing. We're not going to get it this year. If there are lackadaisical manner of prosecuting the matter is in the way that it is going right now. If, as at March 2025, and they can only request a proof of service in September 2025 so that they can brief their counsel, you can imagine that for us to have to engage the Deputy Judge President was because we could see that the delays are simply unreasonable. Now that's the first application, review application, which should take precedence because it's in the High Court. However, the state, within their rights, their dominus litis, in their greatest of wisdom, decided to enroll this matter, whilst alive to the fact that there is a higher court which is seized with a matter which is directly connected to this matter. They argued on the previous occasion that whether or not the High Court finds against them, they still have enough evidence to proceed on the matter. Why then was the purpose of the search and seizure? Because what we are saying in that application is that they misled a magistrate into issuing a warrant for search and seizure. And they still have to answer to that. And the evidence obtained therefrom should be excluded in this trial. I'm not sure whether what they're about to give us in the 64 gigs is part of that or is something else, because they say it's related to emails of accused number 2 and 4. Whether it impacts on our matter, I am not sure. Now there's a second application for review, which was to stop the arrest of accused 1 and 3 pending the outcome of the review. That application is pending. We have now been given a date of 8 October to compel the state attorney to file heads of argument. That's not to hear the matter. It's to compel them to comply with the rules. Now, these delays, Your Worship, are things that could have been avoided had the state not enrolled this matter in the very first place and deal with what is in the High Court, because it's inevitable that this matter is going to be hamstrung. They cannot... We're not in a position to postpone this matter for trial when there's review applications pending in the High Court. Because if that evidence is excluded, what then happens to the rights of the accused? We have consistently asked the court to remove this matter from the court's roll. The final application was a 342 which was brought in December 2024. To remove the matter from the roll because inevitably it was going to be delayed. Your learned sister, Magistrate Soko, refused the application. We brought a review to challenge her decision. There were delays and confusion. We have since filed our heads of argument. The state is going to file their heads. We are going to file a joint practice note and get a date on that matter as well. That's the third review. On the previous occasion, I was under the mistaken belief that the heads were filed, but they were then filed this morning as well. So my learned friend has been served with the heads and they've been filed. They are now on court online. The matter will then go to the registrar for a date of hearing. Now, with those 3 applications pending, what happens to this matter in the lower court? Is that it's going to be postponed endlessly until such time that those matters are dealt with in the High Court. It's inevitable. My instructions are to request this court to remove this matter from the roll. Struck this matter from the roll. The accused have been complying with bail conditions. They were phoned for arrest. They are easy to trace. Accused number 1 is the president of the Football Association. Everybody knows him. What prejudice is the state going to suffer when they are given time to continue with the investigation, as they say. They say the investigations are ongoing. They're going to give us more documents, 65 gigs. They're going to amend the charge sheet. Now, is the matter ripe for trial? My learned friend argues that he is ready to go to trial. But we're saying, well, there's a High Court pending, 3 reviews are pending in the High Court. How are you going to set this one for trial? Unless they settle those applications with us. Then the matter is independent to run on its own. But right now, it is hamstrung. It's yet to be decided whether the evidence that they searched and seized can be used here. We do not know what they searched and seized. They listed stuff, but as to whether it's contained in what they've disclosed to us, we cannot delineate unless they do so themselves. So, what remains, Your Worship, is that the matter gets postponed to the 21st of November, and I must state, Your Worship, that on the previous occasion, before your learned sister Magistrate Soko, I made mention of the fact that we are going to sing the same tune, that there is delays occasioned by the state attorney, the attorneys of the NPA. We have it in writing. The DJP is dealing with the matter now, is case managing the matter. They've asked that their advocate be given until end of September to file heads. But this is because the state attorney has not paid this counsel, and they don't want to brief a new counsel. How does that impact on this matter? It causes delays. Are these delays reasonable when they could have been prevented, when the state was forewarned that these delays are inevitable? What prejudice does the state suffer if this matter is thrown out? They're given time. And throwing it out and striking it off the roll is not the end of the matter. But they're given time within which they can investigate. Now they think they make mention of that they might add other accused. They make mention of all of those things. Now, clearly, the matter is not ripe to be enrolled. It was never ripe to be enrolled. I understand my learned friend's position that he says some of the investigations were prompted by the investigations that were submitted. And thereby, when they had to go and verify the information, they stumbled across other information, and now they intend on adding some of their, or some other individuals. And I've seen one of the individuals is apparently deceased. That's the most probable, closest person I could conclude that they want to add, but is deceased. So I don't know how they're going to go past that. But be that as it may, Your Worship, we've arranged a date of 21 November. However, my instructions are to ask the court not to grant a further postponement because a notice has already been given. In the alternative, this court should set the matter down for an inquiry to be held in terms of 342A for the delays that have been occasioned ever since December 2024. Unless there's anything else you'd like me to address you on. Thank you.
Good morning, Your Worship. Your Worship, I confirm my appearance on behalf of accused 2 and 4. The approach for accused 2 and 4 is slightly different from my learned friend for accused 1 and 3. Accused 2 and 4 are not parties in the High Court litigation. Accused 2 and 4, Your Worship, made representations to the regional head as far back as November 2024. Such representations were deemed unsuccessful. They were then escalated to Advocate Chauke as early as January 2024. A request for further particulars was provided to the defense by the state. The defense responded to the request for further particulars in providing additional information to the state. After a period of 7 months, Your Worship, a decision was still forthcoming insofar as the outcome of those representations, which led to Advocate Chauke's suspension and the current acting DPP having assumed the position on the 1st of September. Your Worship, on the 4th of September, I took the initiative of addressing email correspondence to the acting DPP. I'll read 2 paragraphs, Your Worship. I say to the acting DPP, prior to your making a decision on our representations, we request that you kindly afford the writer hearing an opportunity to meet with you and your deputies at your office. Given the time constraints until the next scheduled court date, being 12 September 2025, a short meeting would allow us to shed light and walk you through any aspects of our representations which you may require clarity on. I'd previously issued a notice in terms of Section 342A insofar as the outcome of representations. To my surprise, there was no response to my request for an audience. Again, to my surprise, Your Worship, I received correspondence at 8 o'clock last night, by chance, as I was not working then. The correspondence makes reference to the fact that the state is still conducting investigations. The correspondence makes reference to a particular email which the state is relying upon, which email was not contained in the disclosure provided to the defense by the state. Now, on the strength of such email correspondence, which is the very same reason provided by the acting DPP to my learned colleague for declining his representations, a decision gets to be made rejecting the representations, Your Worship, without affording the defense an opportunity to explain. Accused 2 and 4 have the right to address the state insofar as any aspects which the state is relying upon to make an informed decision on whether to prosecute or not to prosecute. We were practically ambushed with documents which were not disclosed to the defense. Be that as it may, Your Worship, we told our next recourse is to make representations to the National Director within a period of 30 days. The manner in which the state is handling this matter, Your Worship, is mind-boggling. Disclosure gets to be made. We make representations on the disclosed particulars. We get ambushed with further documents which we are unaware of as consisting part of the state's case against accused 2 and 4. We're not given opportunity to address the state insofar as giving them an explanation in respect of this particular information. So now, accused 2 and 4 have lost the opportunity to explain to the acting DPP the email which he's relying upon, on which he says the state has a prima facie case for them to summarily proceed on trial. As far as accused 2 and 4 are concerned, Your Worship, the investigations are incomplete on the part of the state. It is confirmed by the acting DPP himself in the first paragraph of his response, which I'll read, Your Worship. My apologies for the delay in the response to your representations in this matter. This was due to unforeseen circumstances, and the allegations in the representations had to be investigated further. These investigations are ongoing. I'm told today I'm yet to receive 64 gigs of documents, which now form part of the state's docket, which we had not received prior. So, accused 2 and 4's rights to now approach the National Director, or even approach the acting DPP to address him on the additional information which he's placed his decision on, without giving us the right to address him on those aspects, have been prejudiced. But be that as it may, accused 2 and 4 still have the right to approach the National Director. We are unable to do so within the 30-day period which we've been told we should adhere to, due to the fact that we are yet to receive disclosure on further additional information which the state has received. I would like the state to confirm in this court whether investigations are final and the matter is ready for trial. I would hate a situation where I then exercise my client's rights to approach the National Director and receive a response of similar fashion to the response I received yesterday, wherein reference is being made to information contained in the docket which was not disclosed to the defense. Your Worship, I'll then deal with the pending High Court review matters. In as far as accused 2 and 4 are not parties to the litigation, accused 2 and 4, Your Worship, are prejudiced severely insofar as the conduct of these proceedings. It is likely, Your Worship, that this matter is not going to go to trial anytime soon. I'm not even sure, as I stand before you today, Your Worship, whether or not this so-called additional information emanates from the representation submitted by accused 2 and 4. It could very well have emanated from the search and seizure that was conducted at SAFA House. We're not sure. We might be faced at a later stage with what we call fruits of a poison tree, insofar as the evidence the state would have if the High Court process is successful. I concur with my learned friend in that the plausible or feasible way forward would have been for this matter to be struck off the roll. We told 8 months after disclosure was made, investigations are ongoing. 8 months after, investigations are still ongoing, certain accused persons are going to be added, and there is High Court due process that is pending, which affect the proceedings of this court directly. The best approach, Your Worship, would be to have this matter struck off the roll. Alternatively, if the court is not with me in my request to have this matter struck off the roll, I would have no alternative but to agree to the date of the 21st of November. For accused 2 and 4, it would be for the state to confirm that their investigations are indeed final. I cannot approach the national director in piecemeal fashion. They need to put their house in order before accused 2 and 4 exercise the right to approach the national director for her to review her subordinates' conduct, decisions, as well as the docket. Accused 2 and 4, Your Worship, are on bail. I would request, if the court is not inclined to strike the matter off the roll, I would request that the bail be extended and they be warned to the 21st of November. There's a copy of this.
Thank you, Your Worship. I'll start by addressing the first issue of the review of the search and seizure. Now, I would like to put the following into perspective, Your Worship. When a complainant registers a case with the police, the complainant provides the police with, firstly, his oral statement, then supporting documentation in the form of any document that would be supporting his allegations. In this instance, the complainants provided the police with documents which would be used as evidence or documentary evidence in this court. Now, when the NPA receives such information or docket from the police, it does what we call the decision. It goes through the docket for decision making to determine if there is prima facie evidence in the first place. Secondly, if there is, are there reasonable prospects of a successful prosecution of that matter based on the evidence at hand? And at the same time looking at this matter and the parties involved, there is the history of, and the defense has been using this word on so many occasions, that the other parties are disgruntled. And the state is not oblivious to that allegation or claim. Then when one gets an information from a so-called disgruntled complainant, the sensible thing to do is to test the veracity of the information that you are given by the complainant. In this instance, we get documents which the complainants say, these are the copies or these are the documents the copies of which are sitting with the suspect. The sensible thing to do would be to approach the suspect and say, please give us a statement and please disclose what we need as per the complainant's allegations. In this instance, the suspects were not ready to play ball. They did not even want to engage with the SAPS. What was the next step to be done, Your Worship? The next step was to now issue such a seizure warrant to verify and indeed make sure that those copies, those documents that were given by the suspects are indeed in the possession of the suspects, which are the accused today. And that is the reason for the search and seizure. Now, for my colleagues to come and say, why did we do a search and seizure if we do have evidence? It is not because we wanted an information that we didn't know existed. We do have the information. We just needed to verify so as not to be embarrassed by getting or involving ourselves in fights between the two factions. It would have been very embarrassing for the state to take side of one faction, which is just fighting the other faction, without having verified that the information they are providing is correct, it's authentic, it's correct, it's existing, it's not just a made-up information. And that was a very sensible thing to do. Hence, we told the defense that even if the High Court were to declare that the information seized is not admissible, we do have the same information in our possession, not from the search and seizure, but from the complainants, Your Worship. So our case is ready. With or without the search and seizure information, we are prepared, we are ready to proceed with the matter because we have the same information. Now, the new information was given to the state as the reasons for requesting the matter to be withdrawn. We asked the state to withdraw the matter because of this information, and that information was new, which information involves emails, selective emails. I must stress the word selective emails from accused 2 and 4's email data. The emails are exculpatory, Your Worship. Obviously, we had to go and verify that indeed these emails do exist. What were we supposed to do? To accept the emails as they are, as the gospel truth? And if we did that, it meant we had to have the matter withdrawn because they are exculpatory in nature. They are supporting what the accused is saying. But we had to go and dig deep, only to find that those were just few selected emails. But how do we dig deep? We had to go now to a company that was hosting the backup data of accused 2 and 4, which company happens to be Ekurhuleni. A Section 205 subpoena was issued, served on Ekurhuleni. Ekurhuleni complied and gave us a 64 gigabyte of information. Basically, all emails that we requested for the period that we requested from 2017 up until the recent period. I can't remember the exact period. It's in the documents. 64 gigabyte data comprising of emails. And as we went through the emails, we even uncovered more damning evidence against the accused persons. Now, what do? Do we give a blind eye to the information that is even pointing out to other people? At the same time, we have the High Court applications, which are self-created emergencies, by the way, by the defense, anticipating that they are about to be arrested. They ran to the High Court and tried to have the information thrown out. Now, today it is, their actions are being construed as if the station, or rather the state is delaying the matter. We've been saying this from day one, that abandon those High Court applications. Whatever relief you are seeking can be addressed by this forum, the criminal court. That can be addressed in a trial within a trial setup. That is, it's about admissibility or inadmissibility of evidence. which this trial court or this criminal court is empowered to adjudicate upon. There is no really a need to rush to the High Court, but then it's a strategic move by the defense, so as to create an emergency and create an illusion that the state is prejudicing the accused, because there are other matters that have to be dealt with before this matter can be proceeded with. Now, the 64 gigabytes that my colleagues are talking about are the information that at least is in the possession of accused 2 and 4, because it's even more relevant to them. They do have that in their possession. They just decided to be selective. If they were honest, they would have given us that much of information. We would have received it from them, but we just received few emails of the 64 gigabyte. Obviously, we have to disclose it to the other accused, to accused 1 and 3. It's inevitable, Your Worship. It's not like this is totally new evidence that the state decided to go and sort without any other reason. It's a chain reaction. It's a reaction from what they presented to the state. And of course, we have to discover it to them. We could not give it to them in other manner except through the USB. They need to provide the state with a USB, at least a 64 gigabyte USB, so we can give it back to them. At least to 2 and 4, it's back to them, but to 1 and 3, it's new information. But inevitably, they have to get it, Your Worship. Now, the fact that the DPP said the investigations are ongoing is based on that issue, that we discovered new information. Now, my learned colleague spoke about a deceased person that the state wanted to charge. We don't know, that is news to us. We don't know anything about a deceased person that we're intending to charge. That cannot be true, Your Worship. Be that as it may, if we still have other dates on which the defense are adamant we should remand the matter to, so that other issues can be dealt with. For example, the High Court matters. Why can't we use the period in between to give them whatever we think and feel it's necessary? But be that as it may, Your Worship, the fact is this is a self-created emergency by the accused. If I were the accused, I would abandon the High Court applications and we swiftly deal with the matter in this criminal court. It's about the admissibility or inadmissibility of evidence, which can be dealt with in the trial within a trial. If that is the case, and if the defense were to ask, are we ready to proceed? Yes, we are. We do have enough evidence. In one of the allegations, or rather the claims in the representations, was the fact that it would be unfair to prosecute other people, or selective prosecution, and not prosecute others. And then if we try and be as fair as possible, and see who, because we know that they know who are other people that can be prosecuted, and they're using it as now as a defense and as a show of the state being unfair. And then if we want to satisfy that, it now becomes it's being used against us as an excuse that we are delaying the matter. That is not the case, Your Worship. And as far as the Section 342A application, review application is concerned, Your Worship, Advocate Mokgakabi is dealing with that matter. And from what I've discussed with him, I can determine that my colleague, Mr. Nkwashu, has not really given the true picture of what is happening. And if the court were to allow, Your Worship, I'd allow Advocate Mokgakabi to come in and address the court on that aspect. He's the counsel dealing with the matter in the High Court.
I don't think we really need that further. Issues whether matter should be struck on the roll or whether the matter should be postponed. That's all.
As a court, please, Your Worship. On that basis, Your Worship, there is no ground upon which this matter should be struck off. if everything were to be abandoned, the state will be ready to call its witnesses and put the charges. The fact that the charge sheet may be amended, a charge sheet may be amended up to a stage of pleading, Your Worship. So there is nothing untoward about that, Your Worship. So it should not be used as a reason for a matter to be struck off because the state is not ready. The charge sheet will still be amended. We amend the charge sheets as and when we feel it needs such amendment, Your Worship. As a court, please.
Your Worship, thank you. I have to reply, unfortunately. I need to start, first of all, with the issue of amendment of the charge sheet because it's the last thing that my learned friend dealt with before I deal with what I feel is not a true state of affairs. The issue that the defense takes with the amendment of the charge sheet has got a history in it. There was a time when the charge sheet was amended by removing charges against Mr. Jordaan and Mr. Hluyo from the charge sheet. They were charged for an amount of about 1 million rand, just under 1 million rand, as theft. Those charges were later removed by the state, and they had to amend the charge sheet because they found that there was no basis on which to charge the accused on those counts. So they are not simply amending the wording of the charge sheet. This is material fact which had an impact on the guilt and innocence of the accused. They were charged for theft of up to 1 million rand, only to find that the monies that were actually paid by SAFA were for hotel accommodation, were not going into anyone's bank account. There was no theft at all. So when they say they're going to amend the charge sheet, we have a history of them amending a charge sheet where they've already portrayed the accused as thieves. Now that cannot be left unchallenged. What happened to those charges? They've not explained why those charges were removed, but we know that they were removed because they found that the monies were actually not stolen. So we've got a new charge sheet. Now we're expecting another charge sheet. And the acting DPP says the investigations are ongoing, which means they're not complete. So the state cannot approbate and reprobate. They can't be ready to go to trial, and the person seized with the matter is ready to go to trial, but the one who's in charge says, no, I'm still investigating, and I'm going to give you new disclosure. One hand has to know what the other is doing. That's what we call them the state. They're one person. Now, my learned friend said they had to go and verify information which was given to them by the complainants when they laid a charge. And they had to go and search and seize information at SAFA House because the accused were not playing ball. Your Worship, that is an untruth. Because as late as 15 December 2022, accused number 1 sent a statement containing information which the state requested to the Captain Mokhana, the investigating officer. Reading in copy was my learned friend. 2022, 15 December. When do they go and conduct a search and seizure? 8 March 2024. Because the accused were not playing ball. The accused number 1 had already played ball in December 2022. So that is an untruth. Then what then follows? The accused takes a strategic move to go to the High Court to bring a review application because they were going to be arrested. How did they know they were going to be arrested? They didn't know, but they did not sit on their laurel. Under a month, on the 4th of April 2024, they brought a review application. The state now knows, because they've been served with an application for a review of the search and seizure. What do? They wait until 12 November 2024.
Don't need the paper.
12 November 2024. Apologies, Your Worship. 12 November 2024, they issue warrants and they have the accused arrested. From April to November, they knew that there was this High Court application. The accused did not go there to the High Court just to block an arrest. They went to the High Court to exercise their rights in terms of the Constitution. The state well knew that this application is there, but they still went ahead and arrested the accused. And they are saying the accused were doing this as a means to subvert an arrest. The accused cooperated. As early as 2022, they cooperated. They given warning statements with supporting documents. So it is not true that the accused went to the High Court and created a self-emergency, created a self-inflicted injury on themselves, which is now backfiring by causing a delay. No. The accused exercised their right within reasonable time. It cannot be said about the same thing cannot be said about the state. Because even after they arrested them in November 2024, to date, we are still being told this morning that the investigation is ongoing and we're still going to give you extra disclosure. So, if one has to look at the delays, only one party can be attributed these delays to. It is the state. And the measure should be struck from the law. That's the court, please.
Thank you. Mr. Ndebele?
Your Worship, just one last bite with regards to an aspect I seem to take exception to on the part of my learned friend for the state. Mention was made that the accused 2 and 4 were selective in the information which they were providing. Your Worship, Section 35(3) of the Constitution is very clear. Every accused person has a right to a fair trial, which includes A, to be informed, the right to be informed of a case which he has to answer to. Representations were made on the strength of information that was made available to the defense, the docket, as well as the charge sheet that was provided. We're now being told that there is all emails that were extracted from the email host of accused 2 and 4 from 2017 probably to 2020. I hope, Your Worship, for the state's sake, that this information relates to only emails pertaining to this matter and not accused 2 and 4's other private business relationship, because they'll be faced with another High Court application suppressing the use of such information, because his personal information unrelated to this case would be disclosed. It cannot be that 64 gigs have now been obtained which relate to this matter. The state only has a right to information pertaining to this matter. But be that as it may, Your Worship, it is unfair for my learned friend to cast aspersion and allege dishonesty insofar as certain information that was exculpatory. Yes, indeed, Your Worship. A case was made out for which he had to answer, and evidence was given rebutting the evidence which he had to answer. That's what I have to state, Your Worship, in that I take grave exception to being accused, my clients being accused of dishonesty in being selective in the information that they provided. No further address, Your Worship.
Thank you.
Just one aspect, Your Worship, just replying to Mr. Nkwashu, relating to his clients not playing ball. Your Worship, it's unfortunate I don't have the letters with me, but the investigators were blocked by the attorneys of accused 1, or rather accused 3, from accessing the SAFA house. And in this instance, we're not talking about the statement. We don't want to hear what accused, for example, accused 1 is saying. We want to go and search and see if the documents are in there, but they were blocked. Every time they wanted to access the premises, they were blocked. And that is what prompted the search and seizure. After many attempts, and we do have attorneys' letters threatening the investigating officer and demanding that he should no longer get close to the accused and or SAFA house. So that is on the basis that I'm saying they were not cooperative. And we have that in black and white. We do have those letters. If ever the time comes wherein those letters would be needed, we will be presenting those. That's a copy, Your Worship.
Just while you're still on your feet, Mr. Melvert, what will happen on the 21st day of November?
On the 21st day of November, Your Worship, okay, let me address it this way. On the 8th of October, there is a matter has been set down in the High Court. So we are accommodating that. That is the first aspect. The second aspect is the fact that accused 2 and 4 will receive the documents upon which the decision was made. Especially the backup data on which the decision was made. We are disclosing it to them, and then, to be fair to them, let them decide what they want to do. Do they still want to take the review application further, or are they satisfied? Should we now, on the 21st, come and say, let the matter be set down for hearing, and would the High Court matter have been exhausted? Those are the issues. So on the 21st, it would be the outcome of what happened in the meantime, what happened to the High Court, and then what is accused 2 and 4 deciding upon after the refusal or rather the dismissal of their review applications. Those are the issues.
Been advised to take further representations to the NDPP.
They have been
They're
advised.
supposed to do that within a period of 30 days.
It's not a mandatory period, Your Worship. It was just a suggestion that if they could do it in that period, but it's not a mandatory period.
There are 61 gigabytes of information which is going to be disclosed to them.
Yes.
And if you look at that, if they have to go through every page of 64 gigabytes, 61 gigabytes, they may not be in a position to further submit further representations with the NDPP.
If I may just address that.
I want us to deal with that. I don't just
Yes.
want to see people coming to court and going back and all this.
Exactly, Your Worship. If I may address the issue of the 64 gigabyte. Remember, we're trying to play within the standards and the accepted evidentiary rules. We were able to sift and take out what is relevant. And honestly, and in support of my colleague's submission, a lot of that 64 gigabyte is irrelevant for this matter. But because it's the hosting company, Ekurhuleni, could not go and select one by one. It had to provide all the information. And then we can only sift and use what is relevant to this. All other personal emails and other things are not relevant for this, and we're not intending to disclose them for this court. So if we had our way, we would say, we have 20 emails, here they are. But then, we do not want to be seen as tampering and selecting. Let them have everything, and then obviously they will just go to the relevant.
Have you gone through those that information? You personally, or the state? Has the state gone through that?
The state has been able to sift and look for the relevant information using the search words.
Could it be true that there are other people yet to be arrested?
Yes, it's possible, Your Worship, but it's not a something that can delay the matter. If we have to proceed with the accused before court, that can be done. But then, if time permits, if there are other delaying issues, they can be included, or they can be added later on their own at a later stage. The state has a choice.
And you will confirm on the 21st of November that the state is ready to prosecute? Or rather, the state is ready to lead evidence?
Yes, by the
after the
21st.
21st of
By the
November.
21st, yes.
Thank you.
Your Worship.
I'm satisfied. Accused, you may rise. matter is postponed to the 21st day of November 2025. On that date, the state will report the progress they had made, and your counsel will respond on that date. From there, we'll see what happens. Thank you so much.
As a court.
As the court please.
I'm not sure if there are any other matters, Your Worship.
I'm just trying to.
The is a matter.
May I be excused if there are
Yeah.
no
Oh,
other matters?
Both of you are
There is
excused.
the
Have a
motion.
good weekend.
No, be excused, Your Worship.
You are well
I'm not
excused.
sure if the court's going to adjourn.
Perhaps the court should adjourn just for the media to hear.
Thank you so much. Court
Thank you, Your
adjourned.
Worship.
All rise in court. So then we